Good afternoon, everyone. Thank you for joining us for our November webinar on the Property Occupations Act. Everyone excited? On Monday, we start a new journey in Queensland residential real estate, so we're going to try and cover as much as we can this afternoon in a short 45-minute period. Let's see how far we get. Now, I'll be talking about residential sales, not just letting or property not letting or property management in the main. Now, as I always do at the beginning of our webinars, I'd like to just get a feel of who has joined us. So we'll start with a few quick polls. The first one, here we go. I just want to see where you're all sitting today, whether you're in Brisbane, North Queensland, etc. So we'll close that off in a minute. Okay, another few seconds. Thank you. Okay, all right, mostly in Brisbane, but from all over the place. Now, the next one, I just need to know what is your role, whether you're in sales or admin, etc. So if you can, here comes that poll. If you can answer that for me, that'd be great. And good. Okay, results are in. Thank you very much. And the last one in this lot of polls, I just would like to get a feel so I can tailor the presentation in the webinar to the different industries who are listening. So from what perspective are you interested in today's topic? I presume most of the people, here we go, the poll's up there now. Can you please submit your answer? Yeah, there's the answers, and yes, mostly from the real estate industry, but also many from the legal industry. That's great to see. All right, now we're moving on. What we all know is that the Property Occupations Act begins on Monday. It has a number of provisions in it that are of importance. It deregulates commissions, it removes the overregulation of PAMDA, and it splits the administration of property agents on the one hand from the other professions that were previously dealt with by PAMDA, including motor dealers. So they're the three objectives. They were endeavoured to be introduced in 2010 by the previous government, but that wasn't to be. This government made it a priority to make the changes, and even so, it's taken them 3 years to bring it about. Now, if we can just conduct a couple of more polls before we get started, I'd just like to get a feel of those of you who are regular readers of our e-news, our agent and developer e-news. And I'll put that poll up now. If you can submit your answers, please. Okay, there we have the answers. Okay, we've got a lot of first-timers here today, not previously e-news subscribers. I will put up a link later in the webinar that you can use to register your interest and receive monthly updates on this sort of topic that's relevant to all Queensland real estate agents. So that's a free monthly email that is generally very highly regarded, I must say, even if I'm saying it myself. All right, now another poll. I just want to get an idea of what your experience is with those of you who have had experience with PAMDA. What was your experience overall with that legislation, whether you found it easy, difficult, or whether it was a nightmare? And I know there are plenty of those. So here we go. Here's the poll. If you can please submit on that one. We'll close it off in a few seconds. Okay, terrific. That's a good answer. You see all those answers there. A wide spread. As we know, things were very dire up to 2010. We had a major change then when the absolutely ridiculous rules relating to paperclip and staples and all sorts of other nonsense were finally abolished. But it's taken, and from then until now, to bring about the simplicity which the industry has been clamouring for. In other words, the most basic change that's been asked is to have the warning statement incorporated into the contract itself, so as to avoid the overhead, the cost, the risk of the other rituals that the now defunct PAMDA legislation regulated and provided for. So moving on, just for formal purposes, a disclaimer, if you'd please take note of that. I'll be giving you lots of great information this afternoon, but you need to give me a call for legal advice, or you need to consult another lawyer if you have got a specific query. Okay, so what's happening with the Property Occupations Act? What are the main changes? Well, here we go. These are the essentials. As I just mentioned, the Form 30C warning statement is gone. The drawing attention to the warning statement requirement is gone. The Form 32A lawyer's certificate and cooling off certificate is gone. The Form 27C has been converted into a much simpler Form 8, and the Form 28, and from there on up to 26A, has been abolished, with one form accomplishing all those different appointments. What a great idea. So, what is the new warning statement? Well, in about 40 words or so, the powers that be have come up with a much more useful, much less intimidating advice to consumers that may, in fact, be of some real help. Instead of the nonsense statement that was previously mandated, we now have a statement that can be typed into any contract or will be included on pre-printed forms. Now, ADL and REIQ have their new statement pre-printed, but you can use this statement on a old version contract and type the forms in above the signature block at the back of the contract. It's not ideal, because the new contract forms, which will be released prior to Monday by both organisations, I know that's the case for ADL, and I presume REIQ are on the job as well, but the new forms, the new contract forms have been specifically adapted to the new regime, so preferably use those forms. But if in a pinch, if you get stuck on Monday, these words can most likely be effectively used above the signature block on the back of the contract. Remember that it's an offence not to use the correct warning. The previous warning will be obsolete from Sunday night. Using it in a contract from Monday will be superfluous, and it will constitute an offence. There is no automatic termination right given to a purchaser for failing to observe the requirement on the part of a seller or agent to include the warning statement, but nevertheless it's something that should be observed. So here's how it looks in the ADL contract. Notice the words are included above where the sellers and buyers customarily enter their signatures at the end of the contract. Much simpler than the format previously. So a contract presentation now will start with the front page of the actual contract, and it will contain the contract special standard conditions and special conditions, if any. So what are the requirements in relation to the warning statement? It must appear immediately above and on the same page as a place in the contract where the buyer signs. Now, it is not required to be re-incorporated where amendments or counter-offers are made in relation to the same contract concerning the same buyer and seller and same property description. So that's important to know. That's been the case for a number of years, so there's no real change there. And as said previously, there is no termination consequence for non-compliance. So I'd just like to move on now to the cooling off provisions. And I'm sure of you, we're seeing a change in the market in some parts of Queensland, so I don't imagine there'll be too much termination going on, but still the system is that the cooling off period, there is a cooling off period that still applies, but we don't need a Form 32A, we don't need prior solicitor's advice to effectively shorten or waive the cooling off period. The waiver or shortening can be accommodated in a simple one-line letter signed by the buyer. I hereby waive the cooling off period in respect of my purchase of 110 Smith Street, Gladstone, and signed. That's enough. Same thing if it relates to shortening the cooling off period. I hereby agree to shorten the cooling off period to 2 business days rather than 5 business days in respect of my purchase at 556 Gold Coast Highway, Palm Beach. So there we go. And the termination is allowed as before on payment of a termination penalty. So I think it's all fairly clear so far. You can send in your questions in the chat window on your webinar screen. So if we have time at the end, we'll endeavour to answer some of the attendees' questions. But at the moment, I think everything's reasonably straightforward. Now, straightforward until we get this far. Disclosure is accommodated in the new Form 6 instead of a 27C. So, sorry, new Form 8, I beg your pardon, instead of the 27C. Now, this is what the form that's been prepared. So you're scrolling through here, you'll note that it's pretty familiar. Part 2 includes disclosure to prospective buyer, where an agent may receive a benefit from services that are being supplied. So with this, the Part 2 specifies what we're familiar with under the 27C in relation to benefits that the agent may receive. For example, if there's a commission paid for referrals to a building inspector or a pest inspector, those sort of things get mentioned there, even if the value is small. So that's accommodated in the new form. What's not accommodated in the new form, and what used to be in the 27C Part 3.2, was persons to whom, or entities who can expect to receive a payment from the seller as a result of the sale, and that includes the example in the 27C include lead generation fees, marketing fees, and things like that, or payments to marketers, payments to referrers. Those things were required in the 27C. It was expected that that requirement was abolished, but that is not the case. Although it's not included in the Form 8, what happens is that a new form is required unless it is an agent who's receiving commission fees or charges simply for the sale. It is necessary to have a new form that mentions the benefits that are referred to in sections 157D and E. So there is a conflict with the statement, no need to disclose to buyer how much commission they receive from the seller. That's true, but if sections 157D and E are activated, then those benefits and the identity of the entities receiving those benefits must be disclosed. Now I repeat, that does not apply in relation to agents who are simply affecting a straight sale. But it may apply, it certainly applies to property developers, and it can apply to marketers in the off-the-plan situation or property marketing situation. So in that case, a separate form must be designed and presented and be signed by the buyer before the contract is signed. So just be careful. The 27C requirements haven't entirely been abolished, and there is a separate requirement to disclose those items and get them signed off by the buyer in relation to benefits being received by others out of the sale. Now, so that covers disclosure. Moving on now to appointments. This is required in the Form 6. It must be signed before acting. Now, what wasn't the case before is that there's now a 30-day notice requirement for ending an open listing, and either party may end an open listing at any time by 30 days notice. Let's have a look at a Form 6. Here we go. This is the ADL prepared form based on the OFT design. The appointment covers everything. It covers 7 previously authorised forms are now accommodated in one. So it covers letting, it covers property management, covers auctions, and it covers selling in the usual situation. So it's completed in the usual way, and the price, etc., is mentioned. The term of the appointment. Just remember what I said about you can put an end date in for the service, and there are some issues there in relation to property management, which we'll have to cover on another day. But just remember the form's fairly intuitive, and there shouldn't really be any difficulty there in completing an appointment. Now, as usual, for sales, open listing, sole or exclusive must be determined. We'll move on to that a little bit more. The provision in relation to commission sets out when commission is payable, and that can no doubt be varied. We also see an authorisation there to charge fees, repairs, and we see in the appointment also somewhere there, I may have glossed over it, the provision as to what the commission will be. So that's all very intuitive, with taking time though to go through to make sure you fully understand it. Now we'll move back to the presentation, and we'll see that reappointments also use the same form, which is the Form 6. Reappointments may be confirmed for any period of from 1 to 90 days, but remember that the termination of 30 days can apply in any such situation. Termination on 30 days written notice. Now, a word to remember in relation to sole and exclusive agencies. Maximum term has been changed to 90 days from 60 days, but again there is an option to terminate at 60 days by having given a 30-day notice. So, as was the case before, the sole and exclusive issues must be discussed with the client before they sign the document. They must be given a notice setting out what the implications are and the difference between sole agency, exclusive agency and open listings, and it must be signed by the client and a copy left with them. So that all must be done before they sign. Apart from the copy, It must be the explanation and discussion must be given before they sign. So nothing much really changed there, except from 60 days to 90 days. Okay, so I hope everyone's clear so far on what the changes are. We've got a Form 6, we've got a Form 8, and we've got a new warning statement. So what are the implications if the documents are prepared this weekend but not signed until Monday? Well, if they're prepared this weekend under the PAMBITA format with a warning statement on the front, they won't be compliant if the process isn't completed before Sunday midnight. If it stretches over to Monday, then the documents won't meet the requirements of the new legislation. Now, by what do I mean that the process is completed? Well, the documents must be fully signed by seller, buyer, and the buyer has to receive notification that the seller has signed, all by Sunday midnight. If that has not occurred, then the documents will not be compliant under the new legislation. So my recommendation is to restart again on Monday, or get everything done. Those three things: buyer signed, seller signed, communication to buyer that seller has signed, all done by Sunday midnight. We'll start again. Now, that's because the Form 30A doesn't meet the warning statement requirements that are contained in the new Act. But that is not fatal. It is an offence, but should not affect the validity of the contract. It doesn't affect the validity of the contract under the Property Occupations Act. In other words, there's no express termination right even if there is no warning statement contained in the contract. But it's not to say that there might be some other law that could be brought to bear which could play some role. So best practice, start again if everything's not done by midnight Sunday night. So that's what you need to know about the transitional issues concerning signing up buyers and sellers. Existing appointments continue in force for their term. So if you signed up someone on Saturday for an exclusive agency for 60 days, that continues. So there's no need to rush it out and get a new appointment signed to effect a sale. If you want to extend it, you need to get a new appointment signed during the last 7 days of the old appointment. Now, it's also worth noting that PAMBITA rights for termination, for example, if attention isn't drawn to the warning statement, still persist even after the commencement of the new Act and notwithstanding the new Act. So those rights are carried over. So they're the transitional issues you need to know about. Contracts that are signed up on the weekend, fully signed on the weekend, will continue in force and proceed to settlement in the normal way. Contracts that aren't completely signed up by Monday need to be signed up from Monday in the new form, and they will proceed to settlement in their normal way as well. Okay, we're starting to get a few questions come in. We'll see if we have time at the end to deal with those. But we're making fairly good progress. We're about halfway through now. I know we're covering this at a fairly rapid pace, but this will be posted up as a video presentation that you can use as a resource for yourself and your staff to come back to from time to time. Now, the transitional arrangements may have some effect in relation to off-the-plan sales of land and apartments. That is because of off-the-plan, I'm talking about here of off-the-plan transactions involving put and call options, where a contract is annexed to the option that contract will come into force on the exercise of the option. Now, if the contract next to the option is in the PAMDA format with the warning statement, by the time it's exercised, it won't be in the new POA format and won't comply with the POA provisions. Will that affect the validity of such contract? My answer is probably not, but best practice is for the seller to get themselves in a position to be able to substitute a new contract that is compliant with the new warning statement. So there are no termination rights in relation to warning statements now. So the seller is probably okay to have the option exercised under the old format in a call, or put to them if they don't call in that format. Not ideal, but probably get away with it, in my opinion. Okay, so that we've covered the Act changes in relation to presentation of contracts, warning statements, appointments, disclosure, and we've got a bit of a sleeper issue there in relation to the form that doesn't deal with all the Form 27C issues in 157 and 158 of the new Act, but and we've covered the transitional issues. So moving on, let's just talk a little bit about Commission deregulation. Now, the Act says nothing about deregulation. What it does do, it no longer specifies maximum rates of commission. So that's how deregulation is achieved. What's going to happen in practice? I think you are all better equipped to answer that question than I am. As a consumer, I would presume they will probably stay much the same, at least for a significant period, until there may be some movement or competition which warrants a change either way. What may happen is, in relation to marketing situations, instead of paying large marketing fees, we may see the commission rate set much higher and the agent paying those marketing fees, absorbing them into the commission or accommodating in the commission by some means. So it will have, this deregulation will have some benefits or allow some scope for lateral thinking on that point. In relation to commissions, they of course may only be, the term used in the regulation, worked out by reference to the actual sale price. They can be fixed fees, though. They can be a fixed commission. But if it's by a percentage, it can't be by percentage of a nominal sale price. It must be by percentage of the actual achieved sale price. So theoretically, with deregulation, any rate or value of commission may be charged to the customer. But what's going to happen there is that the conduct issues, of course, will prevail, and if an agent were, for example, found to be charging 25% commission, in a regular cottage sale, one would think that that would be dealt with as a conduct breach. So it's blue sky there, and we'll have to wait and see what happens. No doubt in about 12 months we might get some idea as to how the market is treating deregulation, whether commissions are going up or going down, and in what circumstances they are doing either of those. So also in line with conduct issues, and we should talk for a moment about beneficial interest. Agents previously weren't able to charge commission if they had a beneficial interest in the sale. That is reversed in the new Act, but as with deregulation, they must act fairly and honestly and observe the requirements of the conduct code of conduct or the conduct standards that are contained in the regulations. So there is a Form 7 that applies to agents charging commission if they have a beneficial interest. That's the third of the forms that agents need to be familiar with. I don't have it here now, but it's fairly straightforward. You must disclose the beneficial interest to the seller, and the seller must sign to confirm the disclosure and his or her agreement to that course of conduct. So I've mentioned about conduct standards and code of conduct. The code of conduct that was contained in the PAMDA regulations no longer applies. There is a new conduct standards section in the Property Occupations Act regulations. There were 41 rules in the code of conduct. They've now been reduced to 5, so it's a bit similar. So sorry, it's a lot simpler, but most principles from the former code are retained. All right, so we're making good time. Hopefully we'll have some time for some of these questions that come in. I think everyone will find the new system even much more simple. It'll have to be, won't it, with 7 forms combined into one, and all the requirements about under the old system of how the agent was going to perform the service. Well, that's been abolished and not contained in the new, much simpler appointment form. All right, now a few special mention needs to be made, I think, of auctions. An agent may state that there is a reserve, but not disclose what the reserve is. And an agent must not release a price guide for an auction of residential property. So there has been some controversy about this, as everyone knows, but that's the situation that has been confirmed in the Property Occupations Act. No price guides for auctions of residential property. Now, what about websites where people are searching in a price range for a property that's going to auction? Wouldn't that be an offence on the part of the web portal operator to indicate the price range? Not quite. There is a provision in the regulations about how the website operators should deal with that situation. It's okay to have the property listed and for it to be included in a price bracket, but the statement you see appearing on your screen now must be published in connection with that advertisement to disavow any suggestion that the price bracket is suggestive of what price the property may go for at auction. How are you all going? We're really covering this at a cracking pace. There's a lot here to absorb, but I hope you're continuing to find it instructive. We haven't got long to go now, but there are just a few things I want to cover before we wrap up. Just to mention about the regulations, there are some other changes there which will make life a little bit more convenient. It's nothing major. No employment register. You don't have to keep one. You can, of course. It may be convenient. No longer need to display up in your office your license or a signboard with your name and license status and those of all the licensed persons at the premises. That's gone. But anyone who is licensed or registered must show their license or registration on request. Okay, so that covers the main part of the topic I wanted to deal with today. I've got time for a few questions, so just reading them off from the chat board, I'll take 2 questions. First one deals with the transitional provision. Okay, so Jason is asking, what happens if I sign a buyer up on Sunday, but the seller doesn't sign that day? Okay, we've covered that, Jason, but just to repeat, you must, to avoid an offence provision, have the process started again and get the buyer to sign under the new format on Monday, and then you can close the contract duly under the new process, and there won't be any issues. Okay, all right. A question from Nicole. How does the transitional provisions affect appointments? Okay, Nicole, we covered that as well. All appointments that are signed up before, on Sunday or before, in relation to sales and letting for that matter, continue in force until the time on which they would otherwise expire. But if extended after that date, you must renew the appointment or extend the appointment under the new provisions. Okay, thanks very much for attending. I just have to cover a few more formal things. I promised that I would give you the links to the agent and landlord and developer e-news that we publish monthly, and which covers a number of topics that are of up-to-date interest to agencies, like the topic we're talking about today. So that's available free to those who subscribe. Just click on the link and you can get signed up for that free monthly email. That is, for those who already receive it, very highly thought of, very highly, and very useful for them. Also, we will have from Monday, in place of our existing PAMDA flowchart, we will have the new flowchart that shows about that describes the much simpler provisions relating to contract preparation and presentation under the new Act. Just remember that there are some other formalities that still have to be observed on contract presentation in relation to tree disputes, for example, and one or two other things. So they will all be covered in our flowchart, in our new flowchart, which you can get by clicking on the link that you will find in your chat window. Finally, or nearly finally, we have a special offer for today's participants, a free 60-minute in-person or web session, that is if you're not in Brisbane, to review and offer advice on any dispute that you may have or your office has regarding commissions or appointments. It's valid for 6 months, and the first 3 who respond to me by email before 5 p.m. today to that email address will be the winners. Okay, well, good luck to you in that. I hope that you will find that of some use. I'd just like to get an idea now on future webinar topics. We've got a few topics coming up. I'll open the poll here to see what your interests are for the next session. And here we go. All right, we're seeing some results coming in. Thanks for that. And okay, here are those results. All right, looks like Land Sales Act is at the forefront there of people want to hear about, because of course that's those new provisions that mainly affect off the plan sales start on Monday as well. All right then, well, thank you for your attendance. I hope you found that useful. Carter Capner Law is always here for you and your clients with prompt property and conveyancing advice on a cost-effective basis. So please keep us in mind and let us know how we can help you make your clients more successful in their property transactions a real thrill and a great investment. And not to forget, happy holidays to everyone when we eventually get to the 25th of December. All the very best. Thanks for your attention.